What if the wife denies to give divorce? Marriage is a sacred bond between two people. However, sometimes marriages do fall apart due to various reasons. When that happens, divorce seems to be the only legal recourse available. Divorce can be broadly classified into two categories: mutual divorce and contested divorce. In a mutual divorce, both husband and wife mutually agree to end the marriage. They file a joint petition in the court seeking the dissolution of their marriage. The court grants them divorce after being satisfied that consent has been given without force or fraud. This is usually a faster and less troublesome way. However, it becomes complicated when one spouse is unwilling to let go of the marriage and denies divorce. If the wife refuses to give a divorce, it is known as contested divorce. Compared to a mutual divorce, a contested divorce can be much more emotionally draining and stressful for both parties. But there are legal options available even if the wife denies giving divorce. Hello and welcome to Law Nano. We are here to help simplify Indian family law so you can understand your rights and options. Navigating divorce, alimony, child custody, and other family legal matters can be overwhelming. That's why we provide clear, concise information and resources to empower you on your journey. On our website www.lawnano.com, you will find guidebooks plus articles covering key topics like choosing the right lawyer, building your case correctly, and tips to resolve your case effectively. We break down complicated legal stuff into actionable advice you can use. Whether you need help understanding the law or want to know how to get started in a family law case, we have got you covered. The legal process does not have to be confusing. Visit our website today to get the knowledge you need to make informed decisions. Just click the link in the video description below to get started. Now let's continue with the rest of this helpful video. Grounds for divorce in contested cases. There are several grounds based on which one can file for divorce even if the wife refuses to grant it mutually. Some important grounds are adultery. Adultery basically means voluntary sexual intercourse of a married person with someone other than their lawful spouse. Though adultery is no longer a criminal offense in India, it can be cited as a valid ground for divorce. The spouse leveling allegations of adultery needs to provide adequate proof like photographs, messages, hotel receipts, etc. Witness testimonies can also corroborate the claims. Cruelty. Subjecting the spouse to physical or mental cruelty which poses grave injury or danger to life, limb or health, both physically and mentally, can become strong grounds for divorce. The aggrieved spouse has to back the claims of cruelty by providing relevant medical records, police complaints, photographs of injuries, witness statements, etc. Desertion. If one spouse has willfully deserted the other without reasonable cause, the deserted spouse can cite desertion as grounds for divorce. The desertion should have been for a continuous period of 2 years for filing the divorce petition. Conversion. Change of religion by either spouse can become grounds for divorce by the either spouse as per certain personal laws. The conversion has to be established by adequate documentary evidence. Incurable mental disorder. If the spouse is suffering from incurable mental illness or insanity for a prolonged time, the other spouse can seek divorce by providing authentic medical proof like certificates from government hospitals. Communicable disease. Having a communicable venereal disease which can pose a risk to the life of the spouse can also form grounds for seeking dissolution of marriage if the affected spouse is incurable. Presumption of death. If the spouse has been missing for more than 7 years, the other spouse can file a petition for divorce on the ground that the missing spouse can be presumed dead as per Indian law. Contested divorce process. If the wife denies divorce, the husband will have to pursue a contested divorce by following some steps. Filing the petition. The spouse seeking divorce has to engage a family lawyer and file a divorce petition in the family court of the area where both parties reside. The petition must state the facts and grounds for seeking the dissolution of the marriage. Relevant documentary evidence needs to be attached. Serving summons. The court will then issue a legal notice to the spouse who is refusing divorce, asking them to appear before the court on a specified date. This is known as serving summons. Responding to petition. The responding spouse can file a reply contesting the divorce petition by challenging the claims and providing their side of the argument. Trial and evidence. During the trial, both parties present their case through material evidence like documents and photographs. Witnesses might also be called upon to testify. The arguments from both sides are heard by the judge. Interim orders. The court can pass interim orders related to maintenance, child custody, etc., based on the merits of the case till the final verdict. Final judgment. After evaluating all evidence and arguments, a family court will pass a final judgment on whether or not the petition for divorce made by the spouse is to be granted. Role of a divorce lawyer. Navigating the complexities of contested divorce requires expertise in family laws. Hiring an experienced divorce lawyer is crucial. The lawyer can guide on how to build a strong case with proper documentation, strategy, legal recourse, and presentation of evidence. They can represent you effectively in court.